What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today's video is going to put our justice system to the test. I'm going to give you the overview of a case we've covered a little bit in the past, but just to make sure you understand the facts and what we're dealing with, because when we have a system of justice that needs to be fit and protect the worst of us in order for it to be fit and protect the best of us. And in this scenario, it is a brutal set of facts, but also one of our most important rights. Our Fifth Amendment right to remain silent, our right between patient and doctor privilege. So those privileges and rights are at play here, even when somebody potentially admits to committing the most heinous crime you could ever imagine. We're going to talk about what the arguments are on both sides as to whether or not these statements should be suppressed and gone and not be able to be used in trial, what the policy is behind that, because that's really important. It's not just that we have these rights, but we have them for a reason. And they're important for a reason. We're going to talk about whether or not they should apply here. And then, of course, I'll tell you how I think it's going to end, because we're still waiting for the Supreme Court of New Mexico to make their final decision. Make sure you guys all hit that like button. Make sure you're subscribed. So the Alexee Trevizo case is a difficult one, no doubt. We've discussed it in the past. We went through a lot of the body cam footage at the hospital where she showed up. But the background and the factual scenario of this case is a 19-year-old pregnant teen shows up to the hospital, tells the hospital staff she's in pain, but that she's a virgin and she's not pregnant. She takes a pregnancy test. While they're waiting for those results, she says she has to go to the bathroom. She runs to the bathroom, gives birth, and throws the baby in the trash can, literally underneath a trash bag. Incredibly brutal, incredibly sad. Goes back to the hospital room and gets back in her hospital bed. The cleaning staff ends up finding the baby later, notifying the hospital staff. Hospital staff confirms and ends up calling law enforcement. They bring law enforcement in and they go into this 19-year-old's hospital room. Her mom is there as well. She is 19. You know, there are a lot of dynamics going on, maybe a young 19. But they go into the room. The doctor tells her they know they found the baby. She makes an admission. The admission was, "I'm sorry. It came out of me. I didn't know what to do." Law enforcement's in the room. She's not under arrest. She hasn't been read Miranda. When they leave the room, they tell her they're going to stand outside the door. The big question is, was it custodial? Was she free to leave? Did she feel like she was free to leave? The fact that her mom was there, was she waiving doctor-patient privilege? So were her Miranda rights violated? Her Fifth Amendment right to remain silent, to have an attorney there with her? Was her doctor-patient privilege rights violated? What is protected under that? Is it just for medical treatment? We're going to dig in to all of that today, because we're going to listen to the appellate arguments. Each side gets about 30 minutes. We're going to dig in. We're going to focus on what the arguments are. We're going to focus on the public policy, right? What policy means is why we have these laws. So to give you an example of attorney-client privilege, why do we have that? Why don't we say, if criminals confess to their lawyer, have their lawyer go sell them out? We want to get the bad guys, right? That's the public policy against attorney-client privilege. But the policy for attorney-client privileges, we want people to be protected. We don't want law enforcement or prosecutors to be able to go in there and convict people. We want people to have somebody fighting for them, and we want people to be honest with their lawyers. If they're going to work out plea deals, if they're going to, attack a case, or if they're going to say there's another suspect, or if somebody didn't do it, but they said something that might make them look bad, does a lawyer have to tell law enforcement that? Because they might be able to convict them even if it's not a confession. So that's the public policy for protecting the conversations you have with your lawyer as somebody who protects you and you're innocent until proven guilty in our country. So that's what public policy means. And you're going to hear a lot of those arguments on both sides here as to what the ramifications would be depending on what the final decision by the court is in this case. And both sides have arguments in this case, right? The defense is arguing maybe it was a stillbirth, which would mean Alexee Trevizo did not end the baby's life, but that some other crime she might be guilty of, but not first degree. The medications she was on, morphine, among other things, could that have affected the pregnancy, the baby, her mindset, what she was doing, what she knew, what she felt? The state clearly says she knew what she did. She hid what she did. She lied about what she did. that's all consciousness of guilt, she should be punished to the full extent of the law for the maximum penalty and crime that we have in our country to protect that baby's life. So each side's going to make their arguments. Those arguments will be at trial. The arguments we're going to listen to today is, were her rights violated? And if they were violated, should these admissions be suppressed? That's the question before us, so we don't get it twisted. We're not going to discover if somebody's guilty or not guilty. I know people have their feelings. I understand where I think the evidence is pointing and what I think this case looks like. But as you know, she is still presumed innocent. We will wait until and if and when a trial ever happens, or if she takes a plea deal of some sort. But today we're going to focus on, and Bella E., this is a good kind of segue into our conversation. She violated that baby's rights. If she is convicted, I agree with you. And I think a lot of the evidence points towards you maybe being very correct, even with this thought. And other people saying, doesn't the baby have rights? Absolutely. You're not going to ever find me say a baby doesn't have rights. Absolutely 100%. But Alexee Trevizo has rights as well. And those are the rights we're going to discuss in this video today. So we're going to start out with the side that appealed. So just so you know how we got here, some procedural history. The circuit court, meaning the trial court, suppressed the admission. The state didn't like that. The state didn't agree with that. So they've appealed it up to the Supreme Court of New Mexico. And that is where we are for these appellate arguments today. The state gets to go first, since they're the one with the burden, not in the criminal case, the burden, but the burden of proving that this was, in fact, the wrong decision by the trial court, and that the trial court, or that this appellate court, should overturn the trial court's decision and say the state is allowed to use these statements. Here we go.
You may proceed. Thank you. May it please the court, counsel, and attendees. This case, still at the pre-trial stage, involves two narrow legal issues, specifically whether the district court's decision to suppress evidence was factually supported and legally sound. The district court erroneously concluded that there were violations of Miranda and of the physician-patient privilege.
By the way, as per usual, sound isn't great. I'm going to boost it a little bit and slow it down a little bit just to make sure we get everything here. All right, here we go.
Court's key findings are either not supported by substantial evidence, or even if they are, do not support any assertedly related legal conclusion, revealing that the district court was mistaken about the applicable law. The interaction of the doctor, other medical staff, and defendant, as well as the police, are captured on the lapel video in the record as Defense Exhibit H from the suppression hearing. A careful review of the video is critical to a proper understanding of the issues, as it undercuts a myriad of defense assertions and glaringly fails to support and outright contradicts the district court's findings, as well as various characterizations in the ruling.
Counsel, I'm going to interrupt you in two things. First, you need to slow way down.
He is also reading very, very fast. Okay, so the rest of the video does slow down from there. Everybody understand that. The judge just jumps in. And I heard some people saying these judges weren't fair. They were biased against the state. They're firing all of these they're firing off all these questions, obviously disagreeing with him. This is why it's kind of cool and different to watch appeals. This is what appellate panels are supposed to do. We as lawyers want them to do this, right? I've argued appeals before, and I did moot court in law school, which is basically fake appeals, mock trials, fake trials. So you want judges to do this because they're going to focus in on what issues they find important. And we as lawyers are trying to convince a judge. I don't need a judge to listen to me give a pretty speech. I want to convince this judge I'm right. And how do I do that? I answer the questions they have. So the fact that the judges are asking a lot of questions is actually good. It means they've issue spotted what's important. And if you're going to convince them, you've got to convince them on these issues, not all the other ones that you wrote about. So that's incredibly important. And from my perspective, I think it's a good thing because it's giving the state the opportunity to make their arguments. Sometimes you can also tell where a judge is leaning based on their questions, of course.
Second, I'd like you to address pretty much right out of the gate state versus Ibarra.
State versus
Ibarra. It seems to be a case that answers this question a little bit.
And I'm not immediately familiar with that case, Your Honor. I'm sorry. I'll try to do my best to answer your question.
Okay, so I'll try and tee it up a little bit for you because I don't want to completely catch you off guard. So this is a 19.
So if the defense cited a case, you should know that case as the prosecuting appellate attorney. And I believe the defense cited this case because they're going to talk about it as well. And they don't know that case. It's not a great start.
90 Supreme Court case. And in that case, it's discussing the term interrogation for purposes of Miranda, which seems to be an issue here. And it says that under Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit incriminating response from the suspect. So that's that concept. Does that help?
Yes, and,
Okay,
and I do remember Ibarra. Sorry, I
Okay,
didn't
no,
understand, but then I recognized it was Ibarra, which is cited in the brief.
Yes. Okay. No, that's okay. So I would like you to address that statement that comes from Rhode Island versus Innis, but was adopted.
He's like, oh, I do know that case. I think it's because she called it Ibarra versus Ibarra, and he knew it as Ibarra, so he did know the case, which is much better than not knowing it.
By the New Mexico Supreme Court.
Yes, thank you. And I do recall Ibarra in the briefs. Your Honor is right that interrogation under Innis can be express questioning, or it can be, as Rhode Island Innis talks about, actions or statements by the police that are, as they say, that the police knew were reasonably likely to elicit an incriminating response. The reason why the state believes there's no interrogation here, Your Honor, is when you look at the video, just so we're all starting from a baseline, the police do not ask her any questions at all. The police do at one point ask the mother, does she have a driver's license? They hand that over. Of course, they're going to run everyone for warrant. It's like showing up at a car accident scene. But as I cited in the briefs, we all are familiar with cases that say asking for a driver's license, and that's procedural. That doesn't count as interrogation. So then the question would be, did the police say anything that would be, as Innis says, reasonably likely to elicit?
Okay, a bunch of people are asking who's talking. This is the state. The state is going first. They filed the appeal, so they have the burden to prove. The court needs to overturn the lower court's ruling to suppress these statements. And basically, the first topic for discussion is, was this custodial? Were they questioning her in a manner that would potentially be like an interrogation, asking her questions that could incriminate herself? Was she free to leave? Did she think she was free to leave based on how everybody was situated?
Well, not saying it can be actions as well. And that's what I want to focus on is actions. Because I get that the police didn't say anything, they didn't ask questions. But here, my concern is that if we only review the video, and that's out of context to what the police have been told prior to going into the room. There's been a report. They've heard from the nurse, probably things maybe the nurse shouldn't have told them. And then they're invited to go in. And so there's action as a result of that, that's different than like they just pop their head in, or if the report had just been made without healthcare folks tying the report to this young lady. That might be different if they were just going room to room saying we'd like everybody's name and information. But here they have this body of knowledge before they walk in the room, and that's what troubles me in this case.
So a lot of the questions that the judges are going to focus on is, what makes this case different, or specifically what facts relate to this case? The knowledge they had when they walked in the room and the police presence while the questions were being asked. That's what's really important. Sleuthy said, and what would you do if someone started making incriminating statements when you rolled up on a car accident? So there's a lot, my question would always be, it depends and I need more information. But I will say is a lot of jurisdictions have what's called accident report privilege. So if a cop is investigating a car accident, the statements you give them in order to investigate the car accident and make sure everybody's okay and render medical aid cannot be used against you in the criminal investigation. And when you have a DUI case, a lot of times there'll be two different cops, or a cop will say, okay, I'm ending my accident report, and now we're going to move into the criminal section of this, read the Miranda rights, and start asking them, have you had anything to drink tonight? Things like that. And sometimes if you just admitted you had something to drink or that you're at fault for the accident, the people just keep talking because they're so used to talking about this cop already, or to this cop already. So there are privileges in all sorts of different scenarios. Sabertooth, thank you so much for gifting 5 Lawyer memberships.
Yes, and I'll do my best to answer. And of course, I know we'll get to the agency issue later, that the other side is arguing that the doctor was an agent. But yes, just strictly actions of the police. And I do appreciate the court's questions in focusing this. We know that it's an objective test for custody, but now we're talking about actions that can be arguably that would have caused or been the equivalent of interrogation under Innis. The state doesn't believe the police did anything here. I'm glad that Justice Bacon brought up the question of, well, the nurse went up and talked to the doctors. The charge nurse went up and talked to the police when they arrived at the hospital. I don't see a problem with that, because I mean, generally when the police arrive at a scene, they're going to want to talk to the reporting party. Now, granted, the doctor, whoever it was that called the police. The reporting party here is a little ambiguous. It's essentially the medical staff.
Does this lawyer seem nervous? I don't know if he's nervous, but he is speed talking. And from somebody who speed talks, I get it. And don't worry, I'm going to summarize a lot of his arguments. I'm sure you guys can hear a lot of his arguments. And because I speak pretty quickly, you can just slow down the whole video. So he and I both can slow down our speech in your video if you want to slow it down. Of course, those people that love, speed talking, they'll enjoy this lawyer. Sabertooth said it's Membership Tuesday from Sabertooth, who just donated yet another 5 memberships. Thank you, Sabertooth.
Possible. It's not like a neighbor calling the police on a loud party next door, but the police naturally are going to want to talk to the doctor, the nurse, get a little bit of information before they barge in there. I think the police acted very reasonably here. They talked to the doctor, they talked to the nurse, and I think the police are smart enough to realize that just because this charge nurse is telling them this, that, and the other, that's just for the police officer's information. The defendant didn't even know what was being told to the police. So my point being that nothing that was said to the police in the hallway would have even been known to the defendant. So going back to the
So that's always the counsel. My concern here is, and I'm curious, why did the police feel like they needed to go in the room with the doctor while she's talked about the defendant's treatment? Because the doctor.
And that is a really great question. So Sleuthie, I see you're kind of having a conversations with people on here, which is great. So I'm going to bring up some of these questions because you guys are asking and discussing all of the perfect questions that we are going to talk about in today's video. Since she was getting medical treatment, wouldn't that be similar? And the question is, if she was getting medical treatment, right? We're going to hear that discussion back and forth. Were they just talking? Were they talking about the crime or were they talking about medical treatment? And if they were talking about the crime, should she have been read her Miranda? If they were talking about medical treatment, why was law enforcement in the room? That's what the judge just asked, basically. Joy Morris, aren't they mandatory reporters? Guess what? We're going to get to that too. That's exactly an issue they're going to be arguing about. Sleuthie said, I wouldn't necessarily call it a loophole in the law. I would say that it's critical that you make sure to tell the truth when something happens and they're trying to get medical help for folks. And that's the public policy argument we're going to hear. In car accidents, we want to know what happened so we can treat people appropriately. Lawyers need to get correct and accurate information. Doctors need to help people. So if people are afraid of a doctor turning around and saying, I'm going to report you for committing a crime, that could be an issue too. And we're going to get into all of these discussions today. Sabertooth is going to continue to donate memberships. So hopefully everybody has that turned on. If you don't know how to turn it on, somebody explain how to in the chat because I don't know how to do it either.
Doctor told police before she went in the room, I need to go tell her about what her condition is, what we need to do next. And then she says, will you come with me? Which I find a little strange, but why did they feel like it was appropriate for them to go in the room with the doctor to discuss treatment?
Well, I would say that at that point, they clearly had reasonable suspicion, probably more than that, given that the medical staff was, and I'm doing my best to answer your question, the medical staff clearly knew that the only person that had been in the bathroom during that entire relevant time was the defendant. This was not going to be a whodunit. So you're right, the doctor does say to the police officers, look, I need to tell her what's going on. I got her accepted to Loveless and Roswell. I need to tell her what's going on. She's bleeding. I need to make sure she's stable. The doctor simply says, does one of you want to go in there with me?
No, that's not what he said. She says, I need to make sure the mother is stable. I don't know if she delivered a placenta. She's bleeding a lot.
And that is medical treatment. That is medical treatment. John said, so the nurses shouldn't have told the police anything. So they absolutely could tell the police that they found the baby in the trash can and that Alexee Trevizo was the only one in the bathroom. But the statements Alexee Trevizo makes during her medical treatment are protected. And the mandatory reporting is to stop that kind of abuse or things like that from happening or a crime from happening. It's not the same if a crime has already happened in most jurisdictions. Every jurisdiction is a little bit different. Always, it depends. We can dig into some of those differences, but just, that I'm trying to explain concepts here as we go through. Disappointingly, was she free to leave or were her circumstances such that she was in effect detained? And this is a great question. If you're a 19-year-old girl who just had a traumatic experience and you have law enforcement and nurses standing right there and telling you they're standing right behind the door, do you really think you can leave? Sabertooth is going wild. Absolutely wild here. Another 20-bagger.
Immediately asked the officer, quote, if one of them is willing to be part of the conversation, and invited the officers into the hospital room, and they both agreed. So that's, I want to be clear on what the facts are. She says, I want you to be part of the conversation, and they both agreed. Secondly, maybe this is another way of asking the question that Justice Vargas asked. Is there any medical reason for the officers being in the room when she's confronted? Is there any medical reason for inviting the officers into the room?
I would say I don't know that there was a medical reason for them to be in the room, but
Is there any legal, any police reason? Is she a threat? Is she getting up and running away? Is she doing any of those things? Is there a suspicion she has a weapon? Or is there any police reason for them being in the room?
And to try to answer your question, Justice Beal, I appreciate it. I've watched the video about 10 times. My memory of the video is I don't remember the doctor saying, "Do you want to be a part of the conversation?" I remember her saying something like, "Does one of you want to go in there with me?"
But assume for purposes of
Right,
this,
I
that
understand.
that's what happened.
The answer is I do believe they had a legal reason to be in there. They were conducting an investigation.
Investigation of her medical condition?
Well, investigation of what led to
And you can tell these judges are very skeptical about what law enforcement and medical personnel did that day.
the baby being put in the trash.
No, she says,
But if they're investigating,
she
we
says,
got Miranda.
Well, Miranda requires custody and interrogation, which I'll get to in a minute. But my point is that there's no legal bar to the police going into the emergency in the exam room. Now, granted, I admit, had the doctor said, "Look, I need to talk to her. I don't want you in there yet. Can you hold on while I talk to her?" I think the police, you can tell from the video, they were very deferential to the doctor. One thing I wanted to point out, because I believe now is a really good time to say that, there's a lot in the answer brief that suggests that the police presence there caused a delay or hindered treatment of some kind, or even delayed possibly her being flown to Roswell. I want to be very clear. There is absolutely zero evidence in the record that would support any fact finder in finding that any medical procedure or care was hindered or delayed, or that they even had anything to do with the helicopter arriving. So what I would say is, the best answer I have is I don't believe there was a medical.
He's trying to answer as much as he can in 30 minutes. He's speaking very fast, very, very fast. I get it. I understand. But to slow everybody down, Sabertooth has donated another 20 memberships.
That's a reason for the police to be in there. But clearly the doctor did not say, "I want to talk to her in private. I don't want you in there yet. I know we called the police. We called you, but please don't go in there. I need to talk to her." Do they have a legal reason to be in there? Yes. Now, might it have been
what's the legal reason?
Well, they're
He's like, they have a legal reason. Yes.
investigating this, and they probably want to, at some point,
Watching her get a public exam, is that investigation?
well, later on in the video, when there is a point in the video when the nurse says, will you two please step out? And the police do. They step out of the hallway because there was probably medical.
Was that hindering her investigation? Asking them to leave?
No, it wasn't hindering at all. And the police were very polite. They went out in the hallway. Another thing I wanted to mention too, and again, I think some of this is more clear when you sort of watch the video from beginning to end. There's a point in the video, pretty much exactly at 3 o'clock, where you see the police are out in the hallway and they say to the nurse, they say, "Well, we don't really want to go in there and cause her more stress. She's dealing with a lot." And at that point, at 3 o'clock, you see.
It's kind of like they know exactly why they shouldn't be in there at this point. And she's not going to flee. If you think she committed a crime and you stand outside the room when she walks out, then you arrest her and you read her Miranda and you talk to her. And if she wants to talk without a cop, just nobody's saying you can't arrest her. Nobody's saying the police couldn't do their job. Just do it right within the rules, right? That's the issue. And it's crushing in scenarios like this. I don't like it. I don't want it to happen. This is not how I want it to end up. A lot of the statements seemed absolutely voluntary. Her mom was in the room too, so I think the state does have arguments. But the way these details are starting to come out and we're learning more and more about it, you can kind of understand where the trial court was when they decided to suppress these statements. We're still going to be open and listen to the rest of the arguments by the state. Joanne said, Peter, was the mom in the room? She's 19. Was she a naive girl? Again, this is opinion. She seemed like a young 19 to me. I think she was still in high school at the time. But she was 19. She was technically an adult. They're going to talk a little bit about the dynamic between she and her mom. But at the end of the day, we do need to really make sure we're protecting everybody's rights and that law enforcement does things the right way.
The sergeant and the other officer go back into the room when they've clearly been out in the hallway. And the sergeant says, "Look, we're going to continue waiting out in the hallway. We don't want to add to your stress. We know this is stressful." And the sergeant even explains, "We can't have your mom in here right now. We're waiting for the detective. You are 19 years old, but we're going to keep waiting in the hallway. We don't want to add to your stress." I know at answer brief page 9, it certainly seemed to be making the claim that the police were in their room the entire time for that 2 hours or 2.5 hours. And that's just not true. From 3 o'clock until she was taken away by the helicopter at 4:30, pretty much 99% of that time from 3 a.m. to 4:30, they were waiting out in the hallway. And I don't know if that was answered your question, but
But that was after the incriminating statements were made that were suppressed.
well, yes, but the one thing I hadn't got a chance to get to yet was that it's 3 minutes. It's 3 minutes into the lapel video that they tell her, "You're detained. You're not under arrest, but you are being detained." Put aside, of course, the cases that talk about being detained is different than being in custody for Miranda. even if this court believed that she was in custody at that point, 3 minutes into the appellate video, and everything else was suppressed, she had already made the statements. And that's why I mentioned in the brief in chief that the motion was a little bit broad, and not the other side's motion was a little broad, and not limiting the request to exclude statements to at least the point where she was told, you're not under arrest, but you are detained and you're not free to leave. But it was a little bit overbroad. And the case here, I'm trying to find the case really quick. Yes, State v. Philemon v. 2018 NMSC 11 talks about the difference between investigative detention and a custodial one, is that the latter, meaning custody, involves coercive conditions as to constitute the functional equivalent of an arrest. The one thing I also wanted to notice, and I know I'm not trying to get away from the interrogation, I'll be glad to answer any other questions on that, but of course we know that there has to be both interrogation and custody. Putting aside the agency issues, Santiago case, whether the doctor.
One of the things he's doing too is putting aside a lot of issues, like put aside whether it's custody or interrogation, put aside the agency issue, because the defense argued the doctor was basically acting as an agent of the police, saying, we found the baby, we know what you did, as opposed to, okay, let's talk about, are you still bleeding? How are you feeling? Are you lightheaded? So was she talking medical treatment? The cops shouldn't have been there. Was she an agent of the cops asking questions that were going to incriminate Alexee Trevizo without Alexee Trevizo being read her Miranda rights while the cops are standing right there? There are a lot of issues here, a lot of dynamics at play. It's complicated, it's convoluted, but you're starting to understand how the judges are having to balance this.
Acted as an agent of the police. There's clearly no custody here. And the cases that support that are 3 cases, one in New Mexico and 2 others. State v. Locouture, 2009, NMCA 71. And that's the case that was provided in the Notice of Supplemental Authority back in March. And Locouture, some of the things they say in that case are almost 100% applicable here. What Locouture said was, Locouture, he had been involved in like a DUI or some kind of accident. He was in the hospital for injuries. And what the court said was, the fact that Locouture, this is paragraph 18 of Locouture. The fact that Locouture was restrained by injuries and medical accoutrements warrants little consideration. This is the Judge Kennedy Court of Appeals opinion. Locouture was exposed only to circumstantial restraint, and as stated above, the record indicates no action by Officer Diaz to restrain him. And Locouture, just to be clear, is not an outlier whatsoever. In the reply brief, I cited State v. Garrison, a July 2024 Connecticut Supreme Court case. And
So is it your argument today that the custody was circumstantial custody? Because it's not like, I mean, she's just delivered a baby, is bleeding out. It's not as though she's going to flee at that point. So are you asserting that there was no custody at all, or is it circumstantial custody from your perspective?
Because there was some kind of custody, right? That's what this judge is saying. Chat, where can I go catch up on this? As lawyer, have any other coverage? Yes, I did a couple videos out. It could be years ago at this point. Maybe it was last year or the year before. I did a couple videos. We covered a lot of the statements, what she did. To me, a lot of them seemed voluntary at the time, right? And it's hard to tell where everybody is in the video and what exactly the custody and control felt like. And, her mom was in the room. So it's like, I really can see both sides of this argument. I don't think it's like locked and loaded. These should be suppressed. That's probably where I'm leaning, and we'll see if I'm still there after we listen to all the arguments here. But I could understand why the state really feels like they're entitled to these admissions as well. Caitlin said, how's the Tesla repair going? Mine was in the shop for weeks after a minor wreck. Parts took months to ship. I hope you and the fam are well. Mine was quick within 1 day, but incredibly expensive. It was literally the same day I got it back, but what it costs to fix a wheel on a Tesla is a joke.
Well, custody, of course, can be formal arrest, or as the cases talk about, a restraint on liberty that basically, how they phrase it? Yes, when a person's freedom of movement has been restrained to a degree associated with a formal arrest.
So that was a follow-up question just making I had, which is, so is the restraint of movement of the defendant based on the condition or that there were officers in the room? Does it matter?
Yes, I don't believe it does matter, because Garrison, and there's also this Johnson case that I cited in the Notice of Supplemental Authority 2 weeks ago, talk about the fact that if you're in a hospital, yes, officers may be present, but if the officers are not doing anything additional to limit your freedom of movement, and they're being polite or not being antagonistic, that alone is not enough for custody. And in Garrison, it talks about an example in Garrison at page 289. It's 323 8th 289. The court says, because there is nothing in the record to suggest that any of the officers with whom the defendant interacted were threatening or aggressive, we conclude that the tone and tenor of the questioning weigh against the conclusion that the defendant was restrained. And I can't find it off the top of my head. The court talks in there about the fact that the real key is whether the police did anything to further restrain the movement. And probably the case that really best addresses that is the Johnson v. Commonwealth of Virginia. This is, again, 2 weeks ago, Notice of Supplemental Authority, 916 Southeast 2nd, 910. And what the court says in that case at page 921, so this is 916 Southeast 2nd and 921, the court says the medical equipment connected to Johnson would have made it difficult for him to get out of bed, but his immobility was not caused by the police. Johnson was receiving essential medical care because he had shot himself in the chest.
I follow all of that, but here the police didn't like leave. They stood outside the door. They said, we're standing outside the door. They shut the door. Isn't that some evidence of restraint or custody where they didn't have to, handcuff her because she's medically unstable? But isn't the fact of their presence and standing outside the door to prevent somebody from coming and going, and they're monitoring exactly where she's going, they know she's going to be transported, all of that, isn't that some indicia of further restraint based on the language you just read to me?
It sure seems like it, right? And by the way, another reason this is like popping up in the news is obviously this just happened, but also there's another similar story from, I think, a Kentucky student where, she says she didn't know she was pregnant, had a baby, disposed of the baby, like just brutally sad, like so sad. There are people that want to adopt these babies. I wish, people wouldn't make these decisions. I understand it's traumatic and people don't know what's going on. It's just brutally sad to hear about what exactly is going on in our country and how we deal with it legally, right? And in this case, it's an example, and it's something that people are going to look at, and it's something that a lot of eyes are on. And the defense makes it clear that you have to get it right.
I don't believe that would meet the test of state v. Moon that was cited in the brief, which is the degree associated with a formal arrest. Because again, when you look at Locketeur, Johnson, and Garrison, they really are saying that yes, you may have an IV line, maybe you're injured, you may not practically be able to leave the hospital, but the police aren't doing anything to further restrain you. So I don't believe them waiting out in the hallway would be custody, but certainly any such finding would have to be limited at least to the point about 3 minutes into the Appellate video when they say you are being detained, you're not under arrest, but you're detained, you're not free to leave. But unfortunately, the trial court's ruling suppressed even the statements you made earlier when the police literally were just standing there not saying a word and the doctor was talking. I know that gets into the agency issue.
Well, it also gets into the privilege issue, and your time is limited here. Setting aside Fourth Amendment for purposes of our conversation and the privilege, it appears that the state is taking a position that everything that the victim said is admissible because of the doctor's requirement under statute to report that as a crime. And I'm struggling with that. I can see the doctor, as she did, say we have a deceased individual and I need to report that. But the rest of it seems at that point, you're just opening it up and all the privileges are just waived and whatever that defendant talked about is admissible. Can you address the privilege issue?
Yes, I'll do it very quickly.
So before they get to the privilege issue, a couple good questions here. Mary Beth said, why is time so limited? If it wasn't limited, they'd go on forever and ever and ever. And part of a lawyer's job is you got to be able to condense it. Pages are limited in appeals. Arguments are limited in appeals. You've got to be able to do this. Everyone was outraged at the other girls who put babies in it. She put the baby in a bin. Yeah, I agree. And for people saying, why can't the cops wait outside if she did something like this? It's totally appropriate. That's not necessarily what they're arguing. They're arguing that they did that and did not read her Miranda. If they would have showed up, read her Miranda, they could have done whatever. They could have asked her whatever questions. If she would have said, I want to talk, if she would not have said, I'm asserting my Fifth Amendment right, or I'm not going to talk without a lawyer. And even if she said, I'm not going to talk without my lawyer, they could have stayed in the room. They could have stayed outside. They could have arrested her, when she was medically ready, taken her to jail. Like they could have done all of that. The point is they didn't read her Miranda before she was spoken to and potentially asked questions that led to incriminating statements. Priya said, thank you, Peter, for educating us on the law. And Priya also said, would you fight to keep the statement out, lawyer And I don't know if you've already watched this, Priya, but there's a question coming from the judge to the defense like, what if you guys want this statement to stay in? And I'm going to save my thoughts until we get there in the actual argument.
I'll be glad to do it more in rebuttal. Two things, 11504D4 does have the exception, and as I noted in the brief, this court clearly has, as the issuer of that rule, and I mentioned this in the brief, has a common law ability to interpret that rule. I would say 11504D4 certainly covers this, but the other big issue is the waiver. The fact that she spoke to the doctor with the police present and her mom present.
Okay, so mom's there to take care of her.
Well, she was 19 years old, though.
Okay. And the officers, to Justice Bacon's question, and you can address this, I'll give you some time.
And you kind of see how the appellate court is like, her mom was there, but she was 19 years old. Legally, we all understand, but the judges are human beings. They probably watched the video. And I mean, it seemed like a mother-child relationship, whether or not it was. Is that how the judges are looking at it? That's a great question. Nicole said, Peter, how does your faith deal with this case? Oh, it's absolutely brutal. I think it absolutely should be a crime what she did. I have no problem with her being charged with a crime, but I also see this world and I take justice very seriously and fairness very seriously and playing by the rules very seriously and doing the right thing and the moral thing. And in my opinion, in this case, her rights still need to be protected. If she's convicted of doing this horrible thing and the baby was alive and the state proves the case as they've alleged it, she absolutely deserves the punishment that she gets. And I think that's exactly how a case like this should be handled. That is a life that was taken, and I don't think it should be discounted because of the age of that life. And from my perspective, that's how I deal with it. But that doesn't make me change the way that I see the law, right? And that's really important. And I don't think I don't think just because we want justice means that we throw the rules away. And if we think somebody's a bad guy, we put them in prison. Because we collectively, myself included, could be wrong without this case actually being proven the way it should or her admitting to and taking a plea deal.
They were at least guarding, at least if we're not going into the Fourth Amendment, they were in there. So that's a struggle with that waiver.
And she's on a myriad of drugs.
I understand one.
And so there's the question. A bunch of people are saying, why would she let her use the restroom? Is the hospital going to be in trouble for giving her these drugs? The judges are like, she's also high on all these drugs. By the way, I hope you guys are ready for overtime because we're going to listen to this whole thing. So it's definitely going to be longer than an hour. Hi, it's me. Do they have enough to convict her without her hospital statements? So this is a great question. And I should have saved it till the end. Remind me at the end. We'll talk a little bit about, even if these statements are out, how could you still go about proving this case as the state?
So real quick, the only thing I would say,
Guess what? If you're the state, you never just say, we got enough without them. If you think legally you should get these statements in, you fight to get them in. If you lose, you move on.
Your Honor, if you allow me 10 seconds, is that
It's okay. It's okay.
Imagine if the situation had been the doctor had gone in before the police got there. Let's say the police were on the way and the doctor goes in and says, well, I'm sorry to tell you, but we discovered a dead baby in the bathroom. And then she says, I'm sorry, it came out of me. I didn't know what to do. I think that would not have been privileged. And let's say the police arrive 3 minutes later, because that goes to the heart of the D4, 11504 D4 exception. So I think one way to look at it is, had she made that statement in response to the doctor's statement, we found a dead baby in the bathroom, even had the police not been there, I believe that would have not been privileged under the spirit of State v. Strouts and 11504 D4. And I'll sit down and look.
No.
Take your time.
Justice Moore asked a question. Justice Moore, did you?
I was more clarifying. You talked about the mom being present during the conversation and the statements made by defendant. And yes, the defendant was 19, but I might be remembering wrong. It's entirely possible. I want to see if I am. Wasn't there something she signed authorizing her mom as a caretaker or a party that she wanted? Maybe something where she wanted her to be present during the medical treatment. And does that do anything with the waiver issue? If my question makes sense.
I don't know if I can answer that off the top of my head without going back and looking at the record, but I believe that the general rule is that the presence of a third party not strictly necessary, like a paralegal being there during an attorney and client conversation, causes it to be waived. Thank you for the answer.
Thank you, Mr. Thank you. 10 minutes.
Thank you. Yeah, I just wanted to start off, Your Honor. I will.
All right, we're going to come back to this in a second because this is his rebuttal. So let me pause here for a second and bring up the state's argument. I'm sorry, the defense's argument. All right. So that was the state, and then he's going to have 10 minutes of rebuttal at the end. The defense is going to argue in the middle here. And by the way, notice how the questions change, right? It's like the judges take off their hat where they're like, we want to dig into the state's arguments. They put on their hat. We've got questions for the defense now, which is exactly how it should be. Nina said, my opinion, the cops had no business being in the room while she was still being treated / talked to by the doctor. I think they have enough evidence. Let me know if you guys agree or disagree. Sabertooth gifted 10 more lawyer, memberships. It's a big day for memberships here.
As I said, my name is Amber Fairberg. I represent Alexee Trevizo, the defendant appellate. The legal issues here although that conversation got somewhat convoluted, are actually relatively straightforward. It's the ramifications of this case that are extraordinary for Ms. Trevizo and for every vulnerable patient in New Mexico, and for the state's commitment to safe, confidential reproductive health care. And even more importantly, to maintaining the line that separates medical care from police investigations.
You hear that? That's what we call a public policy argument. So she starts out by saying, this is simple. Let's talk about why it's important. And then she gives the policy reasons.
Physicians and medical personnel take on the role of caregiver. Police take on the role of investigator. If we accept the state's position in this case, that line completely disappears. And it's to the detriment of New Mexico.
Yeah, you can't have doctors going in there helping you and asking you questions to try to get you to say incriminating things while the cops are standing right there, right? As she's explaining it, you start to see the legal argument that she's coming from and why it's so important.
Patients at their most vulnerable moment. Police are in the emergency department every single day. This is something real live doctors have to navigate every single day. And the people who are there are inherently at their most vulnerable moment. There are guidelines here. The state's position is essentially there is no limit. If there is a reason to report, and I want to get into later which reporting statute is actually applicable here. I would argue it's a suspicious death and not child abuse. Those are two separate reporting statutes. But the state is arguing if there's a duty to report, there is no privilege, there is no Miranda rights, there are no more rights. We just go on in this joint investigation.
I'm not sure that I agree that that's where the state's gone. You're blending the two. I think Miranda, the argument as I understand it from the state, isn't related to the duty to report. I think the duty to report becomes important in the privilege conversation that I really do want to explore with you today. But Miranda just seems to be, they were invited into the room and they didn't do anything. They were polite, they were nice. I heard that a lot. And therefore there was no detention, no interrogation.
Yeah, thank you for the question, Justice Bacon. And you're right. You're absolutely right. There is the mandatory reporting falls under the privilege issue, where I think the state is largely mistaken. But let's talk about Miranda for a minute. Let's talk about that custody, because all of the cases that we just heard counsel cite are completely distinguishable here.
So when the state agrees that there was no medical reason for having the police officers in the room, does that bear on Miranda?
Absolutely.
Tell me how.
Absolutely. Well, to answer your question, Justice V. Hill, there are basically two universes we can be in. We can
Also, pro move to say the justice's last name when you answer the question. That's like what they teach you. That's like controlling the courtroom in the appellate process, talking directly to the judge, locking eyes, getting them to understand, trying to convince them. Really pro move. I thought she was really good, by the way, this lawyer.
be in an investigatory universe where Miranda applies, or we can be in, we're here to support the doctor, and we're in the medical universe and privilege applies. The state can't thread the needle through those two by admitting that there is no medical purpose for the police to be in the room. That's effectively an admission that they're there to investigate a potential crime.
But is investigation the same as interrogation and detention?
That question doesn't go to custody. I am interested in that. I mean, does the answer to Senior Justice's question mean they're in custody? Because then you get to interrogation.
Well, I want to make sure I understand your questions. So I want to make sure I understand your questions appropriately before I answer. There is a difference between investigation and custody, but in this case, there wasn't. In this case, there wasn't. And the reason is because of that pre-confrontation conversation that occurred in the hallway that the justices were discussing earlier. And that's that conversation where police are told by the charge nurse that she entered the bathroom to, and again, the charge nurse never treated Alexee.
That really seems related to interrogation. We're talking about custody. The question is,
And these judges keep jumping in. It's like before she can even answer the question, they jump in. But this is it. This is what's tough. This is what's tough about it.
was she restrained? Was she free to leave? Those are the kinds of things we're looking at when we're deciding whether she's in custody. And what I'd really like to hear your take on the two cases where custody is an issue in New Mexico, and we're dealing with medical care emergency rooms, and that's Ibarra and La Couture. Ibarra, we have a defendant who is clearly in custody. He's been arrested already, and he's taken for medical treatment in the emergency room. And then we have La Couture, where they're not in custody yet. Tell me how those cases bear on this situation.
Absolutely.
It's like three questions on top of each other at this point. And Mother of Beagle said, you really have to think on your feet. If I didn't have to write the briefs and do all the research and read all the records, which is so boring, that's why I just don't do appeals. If I could just do oral arguments exactly like this, would it be amazing? I absolutely love it. It can be very difficult. You can get embarrassed if you're not prepared, but it can be so fun. Wendy said, cases like this make me sick. Yes, she has rights, but she made a choice to take an innocent baby's life. That should be the only focus. And Wendy, I totally agree with you. I understand where you're coming from. That's why I wanted to explain at the beginning of the video. We're going to have a trial for that to determine guilt or not guilt. And right now, this is a legal question about statements. So the judges aren't there to determine, did she do it? Did she not? Are we going to treat her like a guilty person? They're treating her like a presumed innocent citizen of the United States of America, which is exactly how they should. What does it legally mean that the doctor didn't tell her the pregnancy test was positive? I don't know what you mean by this question. It really comes down to was the conversation with the doctor solely for medical reasons and treatment reasons? If so, why are the cops there? If it's for investigation and interrogation reasons, she should have been read Miranda. You know, that the treatment answers should have been privileged, so the statements shouldn't come in if it was just treatment. Statements shouldn't come in if it was not treatment, because the cops shouldn't have been in there having her being asked questions without Miranda. So you can kind of understand the two arguments the defense says they have, regardless of if it was treatment or interrogation. These statements should be out. What case do they? I'm going to hold this.
Ibarra says, and I don't have the pin site on me, but Ibarra says, Ibarra uses the term an inherently coercive environment to describe the emergency department. And that's directly contrary to what the Court of Appeals said in La Couture, which effectively said this is just a normal situation, but that was factually distinguishable.
But Ibarra was already in custody. There was no question about custody in Ibarra.
Correct. Your Honor is absolutely right. The reason it matters, though, is because that inherent coercion also goes to custody under Munoz. Munoz gives us, the conversation earlier with counsel got really focused on custody only being a restriction of freedom to the degree normally associated with formal arrests. But in New Mexico, it's disjunctive. We have two ways that somebody can be in custody. There's that way, which normally comes with handcuffs and everything else. And then there's the second, which is that a reasonable person in the same situation, and in this moment, let's put ourselves in the mind of a reasonable 19-year-old high schooler, would not feel free to leave. And that's where Ibarra, I think, is
a reasonable 19-year-old high schooler. I think that was a good way to frame this argument, because you can have 19-year-olds that are absolutely adults with jobs, living out on their own. And then you can have a 19-year-old living with their parents, who their parents make all their decisions. They're in high school. They've got a high school boyfriend. It's just, there are different 19-year-olds. I think we can all agree with that. John said that, so the cops could be in there since it was a medical crime reported. I'm confused a bit. Don't feel bad about being confused. The question is not whether or not the cops could be there. The question is, if the cops were there, what legally needs to happen? If the cops are there for an investigative reason to interrogate somebody that they believe committed a crime, they need to read them Miranda rights. If they cannot leave and they're in custody and they're standing either in front of or behind the door, and the person knows that they're there, and you're asking them questions when you know they've committed a crime and you're trying to get them to admit it, and they do admit it, you have to read a Miranda. If it's just medical treatment and they're talking about the bleeding and doing a pelvic exam, the cops should absolutely not be inside that exam room. So those are kind of the multiple arguments here happening at the same time. Lita said, doesn't this just mean the statements made while at the hospital can't be used against her? Right. We're just talking about whether certain statements can be suppressed, meaning that the state cannot use certain statements against her at trial. It does not mean this case is dismissed. It does not mean that they can't try her for first-degree M. It does not mean that they can't go for everything they want to go for against her. That's not what we're here to decide today.
So important, Your Honor, because it talks about the inherently coercive environment of the emergency department and cautioned police against exploiting it.
I ask you, just in answering that, can you, because the state did, can you, in discussing custody, talk about the 3 minutes prior to the officer telling her that she was detained versus what happened after? Because the state seems to be breaking it up like that. And you might not agree. I'm just wondering if you can address that. Because in my mind, that could possibly be an issue. The 3 minutes prior to them telling her she was detained.
Correct. Yeah. So the questioning started 3 minutes prior to them confirming that she was detained. To my mind, Your Honor, the reason that doesn't bear on this case in the way that the state wants it to is because that was a confirmation. And he said earlier, we heard counsel say, this isn't a whodunit. This isn't who had the baby in the bathroom. So there's nothing that was stated there that would have taken police from a place. And that's where that pre-confrontation comes in with the nurse, where he says, she went in there to harm her pregnancy. She's lied the whole time she's here. She's going to lie to you. And she killed the kid. So they're operating under, we're in a homicide investigation now. She's our only suspect.
And I think the through line of what you're saying is Miranda doesn't require confirmation by the police that you're being detained. I mean, our case law all over the place handles cases where there is no confirmation.
Absolutely.
Correct. You don't have to confirm it if you are detained or you're in custody. So a custodial interview is where Miranda pops in. Nina said, does it matter if you're detained or in custody? Do you have to be Mirandized in both cases or not? I learned both cases by YouTube lawyers. Yes. If you're detained, you're in custody. You're not always detained if you are in custody. Like if the cops shut the door behind you and stand in front of the door, you're in custody. This is a custodial interrogation if they start asking you questions about the case, right? In either scenario, you need to be Mirandized. Chris K, question for the end. Okay, I'll save it for the end. All right, let's keep listening.
And the one thing that we haven't yet addressed, Justice Bacon, is the main difference between those cases on which the state relies and this one is the placement of police, where they're either just in the emergency department, they happen to overhear, or they're standing back, and there's this independent conversation. What we have not seen in any of those cases that makes this one markedly different is that these officers were physically blocking the door. We heard counsel talk a lot about that video. In that video, we see Alexee Trevizo on the bed, hemorrhaging in a hospital gown. Those are the circumstantial ideas, right, that we talked about earlier, that your honors talked about earlier, in terms of circumstantial custody, that she's not free to leave. But that's not what puts her in custody for Miranda purposes. I mean, that's part of the coercive environment that they're exploiting, that they're taking advantage of here. But the reason she's in custody is because she has 4 authority figures acting in concert, only one of whom she's ever seen before. That's the doctor, the charge nurse. And as if you've all seen the video, he's a large man who aligned himself very strongly with police. These 3 men walk into the room and they're physically blocking the door. The operative question for the court is, would a reasonable 19-year-old high school girl in that situation feel free to leave? And the answer is no, even if she wasn't hemorrhaging, even if she wasn't hooked up to an IV, even if she hadn't just experienced the first vaginal exam of her entire life and the precipitous labor and delivery of what the defense posits was a stillborn in the bathroom. Those all contextualize it. Yes, Your Honor.
I don't mean to interrupt you, but I really do want to talk about the privilege. We have not had an opportunity with the state to really talk about the privilege either, but I need you to identify something pretty specific to me because I don't know the answer to the question.
Absolutely.
What, to your client's mind, did the doctor say?
So when they confirm that she's detained, because sometimes being detained can be temporary, but if you're being detained and your rights are being restricted and they're interrogating you, again, I would argue you still need to be Mirandized. But if it's a temporary detainment while they're investigating a crime, usually you're not the target. Sometimes Miranda doesn't apply. In this scenario, in my opinion, they should have Mirandized her, whether they would have said she was temporarily detained or in custody. Again, these definitions and things are very case by case. So it's important that we understand we're talking about them in this case. It's harder to answer questions in the open vacuum of the world, right? Because temporary detention is different than being in custody. If you're detained for a long period of time, would that be considered custody? I would argue a lot of times where people just try to say they're detained, that it actually is custody. And those definitions can get blurred lines depending on the actions taken by police officers. Okay. So technically you can argue that you don't need Miranda in certain situations. I would argue you do usually. So again, I just want to make sure every time I answer a question, just there are always caveats. And if there's more information, it could alter some of the arguments you make legally, which is, of course, why we're here on appeal, arguing whether somebody's detained. Are they in custody? Should they be Mirandized? Is there a doctor-patient privilege? So these questions, this is how we flesh out the answer legally.
What's the actual violation of the privilege? What are the words spoken by the doctor that you assert are a violation of the privilege?
I'm not sure that that's the way, Your Honor, that I conceptualize the privilege. The privilege is a rule created by this court as a rule of evidence. So the question is, so the doctor can invoke Alexee's privilege for her and should have, but did not. And should have a pursuant to medical ethics and her professional guidelines and did not. But in terms of waiving the...
So Alley Cat just said, I'm confused why they're questioning the cops' actions when it's on the medical personnel to ensure HIPAA is upheld and tell people who shouldn't be in there to get out. I'm on the medical field, so it seems like the doc's fault. So if you heard what she just said, I'll back it up so you can hear her answer your question. They're arguing everybody screwed up, right? They violated privilege. But the really important thing and where a lot of the laws and rights in these criminal rules come is with police activity. So that's usually your best argument, but they're also arguing that doctor-patient privilege at the same time. A lot of the justice's questions happen to be focused on law enforcement. So I backed it up so you can kind of hear what she thinks about the medical professionals.
So the question is, so the doctor can invoke Alexee's privilege for her and should have, but did not. And should have a pursuant to medical ethics and her professional guidelines and did not. But in terms of waiving the privilege, only Alexee can do that. And so this is a...
Before we waive, get to, it's a privilege.
Yeah, I mean, why is this? What is
Yeah.
the privilege being asserted here? I mean, I know that it's a physician-patient, but what is happening? What have you identified as triggering the violation of the privilege?
Well, the violation, there's actually 2 different violations.
And that's what I want to try and understand.
Yeah, there's, and you can see this from the court order because we've got the district court made an order, one on the statements made directly responsive to the collective confrontation in the room, and also,
But that's what I want to try and get to, because if the privilege you're asserting that's been broken is the statement of we found a baby in the trash, that's not a privileged statement because it's not about Ms. Trevizo's healthcare. It's just
And that's important too. So they're saying, and this was, brought up in the beginning. I said, you guys are asking all the right questions. What's statements being used for medical treatment and what's not? That's really important. Seems tricky to say whether someone in the hospital room is free to leave because leaving would likely be AMA against medical advice, which has other implications. Yes, all of those different scenarios, the totality of the circumstances, as we like to say in the law, is what the judges have to determine. Mystified said, why would they Mirandize her if they weren't taking her into custody? Just because they're saying they're not taking her into custody does not mean this was not a custodial interrogation. So the defense is going to argue cops were blocking the door. The big man charge nurse was there accusing her of things. And the doctor saying we found the baby. So she's in custody and she's being interrogated. That's what the defense is arguing. Is there HIPAA with the presence of a third party? There can be in certain jurisdictions. It depends. Difference between privilege and privacy laws. I can't go into that. Like right now, off the top of my head, I probably can't make the argument about what the differences are. There are differences. They have claimed the privilege here, doctor-patient privilege. I'd have to do some research to give you like a real good answer you'd expect from me on this question, J. Michael.
a statement.
I'm not sure I would agree with you.
Well, let me finish. So to me, that is not a violation of privilege. The remaining,
I tend to agree. Like just Mirandize her. Just Mirandize her. She's not leaving that hospital not in handcuffs after the information you already got. She went to the bathroom, came back to her room. They found the baby in the bathroom and nobody else had been in there. And her pregnancy test came back positive. Starting to answer the question as to what evidence they have against her. Just Mirandize her.
transport, we need to transport, bleeding out all of that information. I might agree with you as a violation of the privilege, but in this context, given the suppression here, I don't think anybody cares because that comes after the inculpatory statements by Ms. Trevizo. And so if that's a violation of the privilege, sure, it's not what is really at issue here.
What's really at issue here, Your Honor, are Alexee Trevizo statements. It's not the doctor making a statement. The doctor and the nurse both did violate their duty of confidentiality several times by telling officers, I think you said earlier, Justice Bacon, I'm not sure.
And there it is, their duty of confidentiality. They did violate it. That's her argument.
They should have. But to get to the actual statement there's two realms, but the one that is responsive is Alexee's statement, which was made for the purposes of treatment and diagnosis. That's the standard under Rule 504. And the reason here that it is, the doctor comes in and says, I'm sorry, there's police here. We found a dead baby in the bathroom. So this is the first time the doctor has spoken to Alexee, and she made it clear later in an interview, and her actions made it clear at the time, and this is the substantial evidence that the district court relied on, that she wasn't going to get treatment without police present. So this information, the doctor didn't know where the placenta was. Indeed, the placenta was never found. The doctor didn't know anything about the circumstances of the birth. So Alexee's statement confirming that birth is absolutely necessary for her ongoing diagnosis and treatment. The problem here is not, I think where we're a little bit stuck is we're imagining that the police could have come in and maybe the doctor could have said something different that wouldn't have triggered the physician-patient privilege. And I would say, no, the police should absolutely not have been in the patient care room, nor should Dr. Vasquez have instructed her entire ED staff not to interact with Ms. Trevizo except for in the presence of law enforcement. She effectively conditioned her ongoing treatment on their presence. So why?
And that's a problem, right? The way this, and I get it, right? Everybody in the chat gets it. Why the doctors and the medical staff were just feeling miserable, probably feeling a little guilty about letting her go to the bathroom, knowing that she was lying about being pregnant. Like they were probably had all sorts of emotions and feelings, and they were trying to make sure that they got her, right? That's maybe what was happening. But if her rights were violated, legally, there's not really a choice here. We have to suppress the statements if the court finds her rights are violated. Nicole, Peter, my mom and I love watching your videos. We're currently on vacation. Lucky you guys. And got so excited to see your live. Shout out Kimmy. What's up, Kimmy and Nicole? Pumped you're here hanging out with us, even on your vacation. And we are about to hit that 1 hour mark. So you guys know what to do. Hit the like button for overtime. We still got plenty of plenty of this to go through. Hopefully we'll finish sometime today.
Talk to me then about waiver.
Okay, let's talk about waiver.
Yeah.
So here, the state is effectively saying, and this is how I understand it, that Alexee has waived her privilege by the presence of third parties. Well, all we need to do is look at the text of the rule. The rule, and instead of me paraphrasing it, I'll just read it because I think that would be probably better. The rule defines confidential communications, and then we can get to the exception, which is the mandatory reporting exception. But the rule defines confidential communication as a communication made privately, not intended for further disclosure, and then this is the operative language, except to other persons in furtherance of the purpose of the communication. Now that has a little bit of a loop-de-loop feel, because what does it mean in furtherance of the purpose of the communication? We know that from the first part of the rule, which says that the communications that are privileged are those in furtherance of diagnosis and treatment. We also have direct case law on point that says, we look at State versus Roper, and granted, Roper was construing an earlier version of this rule that specifically said family members were exempted from the privilege, from waiver, but the current version of the rule actually broadens it. And it broadens it so that it reflects the reality of New Mexico, which is that no person is going to the emergency department by themselves. Every person has a support person, whether it's extended family, whether it's their mother. I mean, and this idea that she's 19 and therefore it doesn't matter, that's not reflected in the law. The law says that any person, it's not someone who's absolutely necessary for care. It's someone who's there in furtherance of that care.
But so the officers,
Which makes sense, right? It makes sense. That argument makes sense. Joy said, would you represent this defendant? It's impossible to say just from like what I know. I'd have to meet with a client, talk to them about it. Highly unlikely, I would say. And these types of cases are the exact types of cases I never liked and don't want to handle, which is why I don't do criminal defense really anymore. I've had one case in the last 2 years, criminal defense that I handle. I have an associate and my dad handle all of our criminal cases in our firm. I'll consult and help and think and strategize, make arguments, but I really don't like handling criminal nearly as much as I like handling wrongful death, personal injury, nursing home negligence cases where people are injured or killed at somebody else's negligence, no fault of their own, fighting for the victims to get justice, to help them be able to live financially, moving forward in their life because they're put in impossible situations they don't know how to deal with. I personally love that. That's where my heart and soul is really in being a lawyer, and I love it. So that's what I focus on. So highly unlikely I would end up with a case like this.
are in the room and
Officer
they are not in furtherance of her care.
I would argue, Your
Would
Honor,
that be a waiver? I mean, I think the state asserts that that's a waiver, like that she's cognizant of what's happening and makes a knowing decision. I don't care that they're here. I'm going to answer this question. It's not a question, this statement for purposes of furtherance of my care.
I think in that idea, it kind of loops back on there's two things here. One, it loops back on the idea of Miranda, that a statement, any waiver needs to be voluntary. And so for the same reasons, we would argue she didn't voluntarily waive any rights under Miranda. She didn't voluntarily waive any rights.
So, Ms. Faber, assuming for purposes of discussion, assuming that the statement by the doctor, we found a dead baby in the bathroom, was a violation of the physician-patient privilege in the context of everything that's going on, she never had a chance to waive.
Correct.
There's no waiver.
You can't waive a right that you've not been informed of.
And she had no, and by the way, a fact I think that you left out, and I don't think you meant to, on the custody.
So he's about to say a fact that you left out that I don't think you meant to means I'm about to help you out. I'm about to throw you a bone, because here's another argument and fact that helps you.
Is that the officers were armed,
Absolutely.
visibly armed.
Absolutely, visibly armed. And if I could just add one more thing to speak to that, Justice Behill, and also finish answering your question, Justice Bacon, they also fit into other persons, because the reason is because of what the doctor said, that and the charge nurse verified it and said the exact same thing. No one's talking to Alexee, aka no one's treating her except in the presence of police. So in that situation, they're absolutely in furtherance of care, because she's not.
But how is the mom in furtherance of the care? She's actually she was questioning her daughter more than the police were. And it wasn't about her treatment. It was about, you did this and you're going to be in trouble and all of those comments. And in fact, if I remember correctly, I think the police even at one point said, please stop. So how was the mom there in furtherance of her care?
I think we have to step back and look at the totality of the circumstances for that. The statements that you're pointing to, Justice Zamora, or from mom, are her own reactive statements to what she's just learned. But in the course of Alexee's care, she brought her there as her emergency contact. She was asked by medical professionals at one point to help her get into her gown. She's been going back and forth to the bathroom to knock in.
So Diane, no one made her talk. No one forced her to talk. No one forced her to say anything. I tend to agree. But if you're going to ask questions and say things that elicit this information, either from law enforcement or from the doctors that pull law enforcement there and are acting as their agent, so they say, or if it's things in furtherance of medical treatment and you're violating the privileges or confidentiality, that's where the problem comes in. If they would have read her Miranda or said, you're free to leave, but we're going to ask you some questions, right? Or temporarily detain you. You can leave whenever you want. If you want to answer these questions voluntarily, you can, but you don't have to. And then she answered them. Then I think we might have a different scenario. And that's really what it comes down to. Joy said, but I believe our Christian belief should come first, regardless. I'm a Christian before I'm a lawyer, right? My identity is in my faith, number one. But I truly believe that means justice, fairness. The rules need to be abided by. We need to hold people accountable. People need to do the right thing. If we're going to catch the bad guys, we got to do it the right way. That's what I believe. And truth and justice, I think that's really important. And a lot of that has to do with law enforcement following the rules that are in place and protecting people's rights. I think that's incredibly important. Sabretooth just won't stop. Today is the day to be here. And you can, in fact, become a member very easily today, thanks to Sabretooth.
See if she's okay. She's sitting by her daughter's side. She's advocating her. That's absolutely in furtherance of care. Just because we now in retrospect think, oh, some of her statements might have been against Alexee's interests, that does not mean that in the moment she was not there in furtherance of care and that the physician-patient privilege does not attach.
So we have exceptions to that.
Correct.
Let's talk about those.
Let's talk about
Let's talk about a statute that also exempts it, a statute by the legislature. We have, interestingly enough, this privilege existence statute seems unfair rule that's generated out of common law, 32A45. And let's talk about those two things, because it seems to be a high burden on this doctor who has an obligation to report a crime. I think perhaps lawyers have that obligation. Take a separate factual scenario in which they ask a 25-year-old, stabbed in the leg, I killed somebody. They having that conversation as a doctor and a patient, I'm not sure it means the exception doesn't apply. Why doesn't the exception apply?
So you're saying, why doesn't the mandatory reporting exception apply to the statements that are happening after the collective enters the room?
Or under the statute shall not be excluded on the grounds that the matters be subject of a physician patient privilege or of their similar privilege under 32A45.
Right. So I think there's a couple of things here. And one of them is that the report was already made to the extent that it was applicable. And I just want to step back for a moment because we've got two operating statutes. The state has focused.
All right, I'm going to pause here for a second because they didn't ask her any questions though. I know that the statement that is of major focus is, I'm sorry it came out of me. I didn't know what to do. And that came right after the doctor said something like, we know we found the baby. We know what you did. Something like that. I don't remember exactly. That's what they're focusing on. It's not every statement. It's not every statement that she made in the hospital at all. That's not what they're saying. It's specific statements that are in responses to questions or things said that would elicit incriminating statements or information.
Exclusively on 32A43, but there is also for your honors 2411.5, and that's reporting a suspicious death. 32A43, excuse me, is part of the Children's Code, and we know from Strouch and its legislative history that the purpose of that statute is to intervene and protect a child from ongoing abuse, and so hence the mandatory report.
And yes, reporting that they found the baby, where they found the baby, absolutely. But going in and getting statements from Alexee Trevizo is not included in that mandatory reporting.
Reporters that are reporting abuse. And that statute uses the language that a mandatory reporter, and obviously the doctor is one, if they have reasonable suspicion that a child is an abused or neglected child. And then it goes on to a whole slew of legislative rules that have to happen, including.
That's what the state would argue, that this was an abused or neglected child. Therefore, she mandatorily had to report what happened to this baby. So you can see the two sides arguing the different sides of the same coin, basically. McSpunky's getting into the gifting memberships. Thank you, McSpunky.
You have to report it either to police or to CYFD. If it goes to police need to report it to CYFD. CYFD then gets involved. That's not what's happening here. There's nothing in discovery. There's nothing in the record that police ever got CYFD involved because this isn't the operable statute. The operable statute is instead 2411.5, which is reporting a suspicious death. There is no dispute here that doctors did not try to resuscitate this neonate, that they found the neonate cold, blue, very clearly deceased.
I don't disagree with that recitation, but there also is an OMI report, at least according to the briefing. Is this a question of fact?
I think that part probably is a question of fact, but what's not a question of fact, yes, the stillbirth versus live birth is absolutely a question of fact. But the issue of what people knew at the time, as far as a report, there was no OMI report at that time.
And thus triggering the suspicious death statute.
Correct. All they saw was a suspicious death. And so that requires one of two things, either a report to local law enforcement or OMI. And then it's up to those people to take on the investigation. But even if we are operating in the realm of 32, of the Children's Code 32A43 and 32A45, I would still argue, Your Honor, that any reporting is not prospective reporting. It's not an ongoing duty of some sort of ongoing duty of disclosure. That would de facto turn a doctor and any other mandatory reporter into an investigator by police.
The only thing the doctor was required to report was.
And that's the point. You don't want to turn mandatory reporters into investigators or police. That changes the dynamic, right? And that affects a bunch of different privileges. Thank you, Bump It, Cody Hardwick, for gifting a membership.
Reporter into an investigator by police.
The only thing the doctor was required to report was, we found a dead baby.
I would say that the doctor was required to report the basis of her reasonable suspicion for child abuse. So we found, that's what the statute says. And that's what happened. We don't know that the doctor did it. We think it was, and obviously the nurse was the first one to have a conversation with the police. The report was made. Now it's up to them to take on their investigatory tools. It doesn't mean they have an ongoing open entry into her medical records. The other thing that.
So once that report is done mandatorily, then the cops come and they investigate, they interrogate, they read rights, they ask questions, they get the bad guy. That's how it's set up. That's how it should be done. Could the health professionals be implicated for the poor way they handle things? I think that the defense is trying to implicate them. Yes, I think they're trying to.
I would point out, for Your Honor, especially Chief Justice, I want to make sure I'm answering your question, is that the records referred to in the Children's Code, I would argue generally referring to the records of the abused child. It doesn't mean, well, now let's look at the suspect and prospectively and in an ongoing manner have access to their records. That's why we have other investigative tools. They could have gotten a search warrant for her DNA. They could have gotten they could have taken her clothes and conducted communications on those. They could have gotten other warrants for medical records. They could have subpoenaed. They didn't do any of that. Instead, that very night between them and the hospital.
Some of it is based, some of the duty to report child abuse is based on the mother's records, because the pregnant woman who her toxicology screen might report a basis for child abuse, her self-report or clinical observation. When it's a drug exposed baby. So there's some basis in the statute. We're not just looking at the child.
Correct, Justice Zamora. But what that portion of the statute also shows us is New Mexico's commitment to reproductive health care. And what that section says is that mom's status as having used drugs is not an automatic showing of child abuse. So I think here, if we're reading it in total, but I still would urge Your Honors, I think that the morass of 32A43 is avoided entirely by realizing what doctors saw, what they perceived, what mandatory reporters perceived was a suspicious death. We're not in the realm of CYFD. That's just not where we are here.
We're in the realm of doctor-patient privilege.
Correct.
If the defendant would have said instead, same scene, and the defendant would have said, the doctor says we found a deceased individual in trash can, and the defendant said, I killed that individual. Would that have been privileged?
Well, Your Honor, I would say under that hypothetical, no, the reason being that statement would not be for the purposes of diagnosis and treatment.
Okay.
That's, yeah.
It's fair enough. So let's get to the statements that are suppressed and tell us how that falls. Basically, in essence, the defendant said, the baby fell out of me. That, your view, is tied to direct medical treatment because of the hemorrhaging. You understand that?
Not only the hemorrhaging, but what she's describing, what Alexee is describing, what we hear from hospital personnel and what we hear from the state is that from the moment Ms. Trevizo got to the hospital, that she was lying. Well, what do they base that on? That she said that she was bleeding, that she was in 10 out of 10 pain, and she wasn't pregnant. It is surprisingly common how many people don't know they're pregnant well into that case. So that's what they're basing her lying on. But what it really shows, and
But they delivered at 10.
Not only that, Justice, but also it shows an obstetric emergency. She was probably having a placental abruption. And so what her describing to the doctor what happened in the bathroom would have been extraordinarily important. It is extremely unusual for a woman to be able to go into a space and within an 18-minute period deliver a baby deliver a placenta and then walk unassisted back to her room. That demonstrates the amount of morphine that she probably had in her system at that point, because I think, just as a matter of common sense, that's not something you should really be able to do. She would have been, so the idea here is she was in the midst and continued because of the hemorrhaging in the midst of a placental abruption. The doctor did not know where the placenta was. Had any of that been retained in her uterus, she would have bled out and died. So the idea here that her job, she had nothing for medical purposes to say to the doctor is simply not the medical reality. They needed to have an open conversation to make sure she got the care that she needed.
Can I ask?
I think she argued a lot of facts there that I think the state would be like, that's not true. We disagree with that. That's a factual argument. But she's arguing all of this context as to how this can be for medical treatment versus saying, I ended the baby's life versus it came out of me. I didn't know what to do. I'm sorry. Because that could be considered, okay, it came out of you. What came out of you? Where did it come out of you? What else came out of you? Are you still bleeding? That's part of the medical treatment. Riri said, a question, a patient's being escorted into the ER by law enforcement after a crash. Law enforcement intends to interview them ASAP. Patient admits taking illicit subs as doc inserts an IV in front of Ellie. Is this privilege? Thank you. I need more details. With a lot of these hypotheticals, I need more details. Is anybody asking them questions? Why is law enforcement there? Why didn't law enforcement read them Miranda if they were going to interrogate them and ask them those questions? If they just said it out of nowhere with nobody asking them any questions, that's a voluntary statement. If law enforcement is near you when you admit to a crime, that's fine. That's not what we have here. The doctor brought law enforcement into the room, knowing what they knew, saying, we know she did this. I am not going to do any medical treatment unless law enforcement's there. Law enforcement stand by the door. I'm going to tell her we know and see what she says. Very different scenario than what we have here. Karen, do we know anything about if an autopsy was done on the baby? Was it born alive? I'm not positive. I know that's a factual dispute that both sides are arguing. I don't know if anybody in the chat knows if an autopsy was done. I'm not sure. Joy, how was she given medication without being fully examined first? I had a severe dog bite and couldn't get a morphine drip till I was fully examined by a doctor. Just asking. I don't know the answer to this. Cleansed and fire. My favorite thing about trials is watching lawyers make the best arguments based on the circumstances, and this defense attorney is doing fantastic. I tend to agree. I think she's doing a really, really good job with this argument.
That's a really different question that's just been weighing on me. So
this is a very weird question the justice asks. I think it's irrelevant, not something she should even ask, nothing that has to do with the appeal, but she's like, this question was weighing on me, so I want to ask you, and guess what? You're the judge, so you get to do that.
The court agrees with you on either Miranda or privilege. The case goes to trial. You've indicated today that the basis of the defense will be stillbirth. Aren't her statements supportive of her own defense that you're working so hard to exclude here?
The judge is like, what if, I get what you're trying to do, but if this is what you're arguing, don't you want these statements to come in? The obvious answer is, Judge, we can later stipulate with the state that these statements come in. But if they shouldn't come in, we want them out right now until we decide whether or not we want them to come in, right? And if we agree with the state. Number two, we're not tied to any one theory or defense at this point. So that could always change. And if it changes, we'll deal with it. But right now, we think they should be suppressed because we think they do more harm than good, and we think her rights were violated. I mean, this is getting into the defense's legal strategy, which is really not something they should be considering at this level. Is the doctor-patient privilege automatically waived for the visit when her mom is present and discussing with her and the doctor? No, it's not automatically waived. Third parties can be present in furtherance of the medical treatment. She kind of argued different cases already about, when is it in furtherance? When is it not? People don't usually show up to the ER by themselves. She would argue her mom was there to help in the medical treatment.
And so I see, you all will be gone. There will be a new attorney involved, probably a public defender.
That was weird too. Why did she say that? Unless this is just an appellate attorney, why would she be gone? And why would it be a public defender? I thought that was very random.
And we will have excluded statements that are consistent with what her defense is. And that just troubles me in a weird way. That's why I said it's just a related but far field question.
Yeah, I think that I appreciate the question, Your Honor. And I'm not going anywhere. I'll be there for trial to the extent it happens. But that's just not the operative question for the court to think about trial strategy and so on. I would point the court to State versus Gutierrez, in which this court has decided that they take a different approach than the feds do, for example, on constitutional rights.
Most things.
On most things. And that approach is we vindicate her rights because they need to be vindicated. not for deterrence, not for anything else. Her rights were violated. What we need to do here today is try to right that wrong. And then when we get to trial.
She decides to voluntarily use the information.
Correct.
No harm, no foul.
Correct. Exactly, Your Honor.
Thank you.
I realize that I am running with only 38 seconds left to go. And so I just want to highlight for the court, and I want to make sure I answer all of your questions, but I want to highlight for the court the policy impact for New Mexico of this decision, that it really matters. The stakes here just reach far beyond Alexee. If the state's position is adopted, the message is clear. And that's in moments of crisis, patients can't trust what they say to medical staff will remain confidential. And that's going to chill patients, especially adolescents, especially our rural patients, especially our vulnerable people.
And this is her policy argument. This is why you have to rule in favor for us, because it's going to affect so many other people, not just Alexee Trevizo. Do you agree with it? Do you not? This is sometimes really strong for lawyers to argue the policy.
It will also destabilize the physician-patient relationship that forms the bedrock of our healthcare system. And the district court drew that line correctly. Miranda and Rule 504, the relevant medical ethics, mandatory reporting statutes being narrow, that's where the line lies. In this case, it was completely obliterated. So to erase those safeguards would not only reweigh the facts, we haven't talked about standard of review here, but it would not only reweigh the facts, which is what the state's in court in encouraging this court to do, but it would also reshape emergency care so that vulnerable patients would be at risk. And I just want to end on one thought, Your Honors, and that's that this case isn't about whether hospitals can notify police of a suspected crime. They can. And in most cases, they must. It's about what happens after. It's about what happens after that notification. Doctors are caregivers. Police are the investigators. Our law keeps those roles distinct. And it's essential for New Mexico that we continue to keep those roles distinct. And I just want to thank Your Honors for your questions and also ask that you please affirm the district.
Okay, so let's take a second here. We're going to listen to the rebuttal. But I want to throw a couple questions up here. Is there a way to move forward while removing the statements? What case do they have without statements? It's hard to have any sympathy for these young women. I was 18 when I had my daughter. They are simply acting selfishly. She's now 16 and she is my world. You're not going to get any argument from me there. And then Bella said, how could you find out if a crime had been committed without asking questions first? Okay. So I'm going to answer all these questions right here. Here's the case. And here's how you can determine if a crime happened without asking a single question to Alexee Trevizo after you find out a crime has been committed, right? There's multiple scenarios. Number one, she comes in, she says she's a virgin, she says she's not pregnant. You give her a pregnancy test, you have the answer that she is pregnant, she lied. She went to the bathroom, came back, cleaning lady found the baby in the bathroom, deceased. That right there, if I'm a prosecutor, I think I can win that case. I think that's beyond a reasonable doubt. I would charge her with that. I would go to trial with that. I would present that to the jury, along with the cameras of her walking back and forth, holding literally like the baby is coming out right there. Obviously, we need to know the argument with the stillbirth and whatever. There's always nuance, okay? But those statements from the nurses that saw her run back and forth, right? Those statements, videos, and that information that you have, to me, all still is at play. And other statements that she made could absolutely still be in play. You can also subpoena her medical records and get her medical records and see what she was saying, what's in the medical records, what's not in the medical records. The non-privileged information, the non-confidential information from my perspective is enough for the state to go forward and potentially get a conviction in this case. Now, putting that aside, I think the defense maybe convinced me here that either this was a privileged conversation law enforcement shouldn't have been there for, or if law enforcement should have been there and it wasn't about medical treatment, then it's a custodial interview, as a custodial interrogation, and she should have been read her Miranda rights. I really think both can be true. And that's where I'm kind of sitting at this point. But let's take a listen now to the state's rebuttal here. It's about 10 minutes. And then we're done.
We'll try to talk slower.
It's a lot. It's a lot. I think as you have this conversation, if you can help us separate Fourth Amendment part and the privilege, but go ahead.
Yeah, and I did make some notes, and please jump in with questions, but I did make some notes about just a few things I wanted to really hit quick. One is that I don't think there's any issue here about whether the doctor had a duty to report, because whether you call it under 32A43, and I did realize that 32A43 talks about a neglected or abused child, but as I pointed in the brief, just from this court's common law interpretation, and it would be odd to say, well, you have a duty to report an abused or neglected child, but not a dead baby. And I'm not going to read much. I don't want to get into the details much, but the defense's own Exhibit D at the suppression hearing, the defense's own Exhibit D, as in Delta, talks about how the Leela, the custodian lady, what caused them to call the police was that she had found a baby wrapped in a trash bag under another trash bag. Now, as sad as that is, clearly that's a suspicious death. No different than if a 30-year-old had been found in the cleaning supply room with gunshots to the head. So I wanted to make a few other quick points. So on custody, I know there was a lot of talk about what the charge nurse said, and I maybe didn't articulate this really well earlier, but my point was that whatever was told by the charge nurse to the police would not have affected the defendant's objective, reasonable view. It's an objective view of what a reasonable person in that situation find themselves to be in custody. And none of what was said to the police in the hallway would have been known to her. It's worth just a few.
But it's not about what was known to her. It's about what was known to the police when they said, yes, sure, we will go into the room and have the conversation with you, because that's their yes to the statement. So it's not about what she knows. It's about what the police know and what their motivation was to go in the room and have a conversation with Ms. Trevizo.
And I understand that, but and certainly if the police had gone there, gone home with their guns drawn or something, saying you're not going anywhere, and immediately have made it clear you're in custody.
But they don't have to see any of those things for it to be custody.
And I understand.
He's arguing like the extremes, which all the case law has already disagreed with. It's like, sir, we all know they don't have to do that for you to be in custody. We've all been over this. Sabertooth said, I feel like this would be a non-issue in Washington State. She would be more likely sent for mental help, not prosecuted in Washington. We tend to be more liberal and want people to be helped, not punished, for better or for worse. I mean, that's interesting. I mean, everybody's going to agree and disagree with different jurisdictions and how different states handle things. To me, if the state proves what they think they can prove, from my perspective, should be a crime. But I realize people are not all going to agree with me, and that's totally fine. I like different backgrounds and thoughts and viewpoints. I love it. I love the diversity of thought that we have here, different religions, races, genders, ages, everything come in here and be able to discuss how our country is set up and how we think we should move forward, legally speaking. So I'm all in. I'm all in for that.
I know, but certainly what the defendant is perceiving or hearing is what is the defendant perceiving and reasonably hearing and seeing. The one thing I wanted to point out is this reference to the police being armed. I mean, it's common knowledge to anybody that the police are armed. They could be safe 1 minute and 10 minutes later be dealing with a very dangerous situation. I'm not saying in any way, shape, or form the defendant.
But what about where they were standing in the room? Opposing counsel talked about their location in the room, which was in front of the door. That doesn't seem to support the position that it was not in custody.
Although I would argue that the fact that for nearly about 2.5 minutes, they said absolutely nothing. They just stood there and observed, certainly bears on defendant's perception. Just a quick 1 or 2 quotes from Garrison, because Garrison really, the Connecticut case gets to the heart of this. Garrison talks about not all restrictions on a suspect's freedom of action rise to the level of custody. And then they go on to talk about whether a reasonable person would believe that there was a restraint associated with a formal arrest. But another thing that Garrison...
Exactly. Whether a reasonable 19-year-old girl in her position would think that she was in custody. That's the question. Karen said, none of us were there. None of us know what the state of her mind was. A terrible thing happened, but she is presumed innocent at this point. Absolutely. Absolutely. And it's fine if you guys want to say, of the facts I know, she seems absolutely guilty. I think the state's going to convict her. That's fine if you guys want to do that. Legally speaking, she is presumed innocent, and she remains presumed innocent until she pleads or is convicted. J. Michael said, we must err on the side of protecting rights over winning convictions. Trampling her rights implicates all of our rights. I agree with this, obviously, 100% as well. And again, it does not mean this case goes away. It does not mean the charges are dismissed at all. It does not mean that at all. It just means, should this statement or these statements be suppressed?
And since I guess this is the part I looked for earlier, I couldn't quite find earlier. Garrison says there's nothing in the record to suggest that a reasonable person in the defendant's situation would have perceived the police officers to be exercising any control or authority over the medical staff. Indeed, the record demonstrates that the officers did not assert control over the medical staff and that the questioning did not delay, interrupt, or restrict the defendant's medical care. I don't want to belabor the point, but if you do get a chance to see in Johnson, the Virginia case from the notice 2 weeks ago, Johnson gives a list of the kind of factors that might be relevant in a hospital, and one of them is whether the police maintained a constant presence in the patient's hospital room. As I noted, from about 3 a.m. to when she leaves in the helicopter at 4:30, you can tell from their camera they're out in the hallway. But one other thing I wanted to
But they
mention,
told her.
and I understand,
They're out in the
but she already
hallway.
made the statements.
And they,
To me, I think this guy kind of knows he's got a losing argument when he makes certain arguments like that. They were outside. The judge is like, yeah, but they told her we're standing right outside. What do you think that makes her think? Does that make her think she's free to leave if the cops are standing right outside the door after they were just standing inside after the conversations they just had? He's like, I know they told her, Judge. I get it. He's making an argument. I just think he kind of knows where he's at. Oh, Chris said he's going to leave these. Okay, I got a couple Chris questions at the end.
Equivalent to being in the room to be like, we're standing out right outside the door.
Yes, but again, at the point of the 3 minutes into the lapel video, when they tell her you are detained, you're not free to leave, you're not under arrest.
You're the one who raised they were outside the room. You want to focus on the 3 minutes, but you also want to focus on, oh, they were good guys. They left the room after the 3 minutes. Can't conflate it.
And I understand, but my only point is that even if the court wants to consider the point where she's told she's detained to be custody, the motion should have been more specific on that, because I don't think there's anything in the first 3 minutes until she's told she's detained that would lead a reasonable person to believe you were in custody. And I would be remiss without at least mentioning this. If you look at the judge's findings at RP 159, I'm sorry, 158. The judge in her conclusion of law number 3, record number 158, the judge says, Dr. Vasquez, by failing to advise Trevizo for right of confidentiality, and she cites Rule 11-504, acted as an agent of law enforcement. I'm not reading the entire paragraph on RP 158, paragraph 3, but the judge seemed to be reasoning that because the doctor did not go in and affirmatively say, before you say anything, you have a physician-patient privilege, that the doctor's failure to advise the defendant of that made her an agent. There's several problems with that. That's not the test that Santiago provides. Santiago, of course, is the case. This court, 2009 NMSC 45 says it's A, whether the government knew of and acquiesced in the conduct, but 2, whether the party performing the search intended to assist law enforcement efforts or to further his own ends. And Santiago makes it crystal clear in paragraph 24. It makes it clear that if it's a mixed motive, that's not enough. So in other words, even if the doctor was thinking, well, I do want to help the police, but I'm also concerned because I'm the doctor, I'm in charge of the ER, it's 2 o'clock in the morning, they're going to be our Artesia General Hospital Board of Directors to answer to. I need to find out what's going on. I also need to find out how it impacts her care. Because one thing that's clear from the video is the doctor through all this made it clear, your care is paramount. Even Sergeant Anaya says, the number one priority is your care. We're going to step out if we need to. And the number one priority is your care. There's no evidence in the record that the doctor was motivated solely to help the police.
wait a minute. This girl goes into the emergency room. She's got these backaches. She's asked, are you pregnant? She says no. They then do a pregnancy test. It comes out positive. They don't tell her. They don't tell her that the test shows she's pregnant. After the baby is delivered in the bathroom. So she comes in and says, we found the dead baby in the bathroom. Worse to that effect. It gives weight to the assertion that they thought from the beginning, the doctor thought from the beginning, she lied when she said she wasn't pregnant. And now she's confronting her without the benefit of having given her any medical information that she in fact delivered a dead baby. So that seems to me pretty agency oriented in terms of assisting the police.
Okay. And I want to save this question because somebody said Miranda's only for when you're being arrested. That's not true. There's a thumbs up. It's for a custodial interrogation. And then this person said Miranda is for questioning. It's not only for questioning. Most jurisdictions define it as, because every state has different laws on it specifically, but generally speaking, it's any action or questioning by police that's reasonably has a reasonable likelihood that it may elicit something that's incriminating. So action or question. So a statement like the judge just said, we found your baby in the trash can, I think you could argue that's reasonably likely to elicit an incriminating response or an admission or a confession from a 19-year-old who just lied about her pregnancy and went to the bathroom and did this and immediately came back and was having a medical event that she had to be rushed to another hospital by bay flight, by helicopter. So I think all of that is pretty reasonably in that vein of statements, actions, or questions reasonably likely to elicit to where Miranda would apply, in my opinion. I understand if people disagree. I don't think this is cut and dry and easy.
Well, again, Santiago says that it has to be solely to help the police. Santiago says that there's any kind of mixed motive, like you have a professional
An
interest.
inference can be made, it is solely to help the police.
I don't believe that inference can be made under Santiago, but I will say this, Justice, and I think this points to a good point. Even if you give the defendant the benefit of the doubt that she did not know she was pregnant, immediately upon giving birth, the natural thing you would think anybody would do is, help, I just had a baby, help, I need help. She did not tell anybody for 30 minutes. It was 30 minutes later that the cleaning lady found the baby, and obviously another 5-10 minutes till the police showed up. I think one can make a good argument that she did not even from the beginning avail herself of the physician-patient privilege. State v. Roper, 1996 NMCA 73, paragraph 6, said the privilege is designed to encourage patients to make complete disclosures of symptoms. I would argue that if you're hiding a material fact from the doctor that you just gave birth to a baby, you're not asking for help, arguably, you're not even availing yourself for a privilege. Now, I understand after the fact, now that she's caught and she's in trouble, she wants to say, my privilege was violated. But State v. Strauss, 2015 NMSC 9, paragraph 44, states expressly, privileges often have limits, particularly where there are conflicting interests that may outweigh the interest of confidentiality. And it's interesting that Strauss notes in paragraphs 29 to 31 that New Mexico in 1973 became one of the earliest states in the country to impose a mandatory reporting duty on all persons. So New Mexico has a rich history of protecting children and babies. And the other one more thing I wanted to note is it's also interesting that some of this privacy and privilege is a little bit pick and choose what serves me. There was a lot of emphasis in the answer brief about privacy, and they didn't respect her privacy. And yet there's something in the answer brief where they say, well, the hospital let her go to the bathroom unattended. Well, she's 19 years old. It's ludicrous, almost incredible to me that they expected the doctor to go into the bathroom or a nurse to go into the bathroom and stand over her to make sure she didn't do anything. So there's got to be some treatment of, you're 19 years old, you're a responsible adult. I think that's been a little lacking here in terms of the defendant certainly has rights, she's on trial, but there has to be something said for the baby's rights too.
Thomas, anything else? Any other questions? All right, thank you.
Thank you.
And I agree with him. The baby's rights are tantamount, are so important. And the baby is a victim in the criminal case, and these criminal charges should be able to go forward, in my opinion. But that's not really what we're balancing here. Sabertooth said, all this is why I never wanted to be an OBRN. They have a duty to both mom and baby. I was happy with being an adult ICU RN. Now I'm happy with being an adult pulmonology NP. Caring for babies and children is hard. I mean, the medical field is hard, I think. I really do. And if you look at the legal field and how lawyers have to deal with situations like this that are brutally sad, people are going to be mad, and they're justified in being mad because they have righteous anger over what's going on and the innocent life that was lost. And then we as lawyers still have to be kind of callous and cold and making the legal arguments of what should happen. So I hope you guys can understand that and see that in these arguments, how this is what lawyers have to do. They got to put that hat on. They've got to put their big girl or big boy pants on and go to work and make these arguments to protect everybody's rights. Tracy said, I thought her mom and doctor asked all the questions. The cops just told her she couldn't leave, and they told the mom to stop asking her questions. So these are factual questions that, you know, they went through, and they're focusing specifically on some statements made by the doctor as an agent of law enforcement is what they were arguing. And they went through exactly what those were. Chris K said, Peter, question for the end. Can you get parts of the statements in through hearsay, mom, doctor, nurse? Do they really need the statement? Isn't the linchpin evidence of live birth, causes of action for civil case? Yeah, I mean, I think they've got a lot more than just this statement from her. And you're right. There's a lot of different statements they can get into. There's a lot of information that they can get into, the videos they can get into, tons of evidence they can still get into, regardless of if these statements stay suppressed. Side note, I was shocked to hear on the podcast that your dad has lost a case. I assume it is no more than 2, right? Hey, you're not trying cases and you're not handling cases if you're not losing cases, right? There are battles every time. Both sides think they're going to win. You win some, you lose some. The point is the good lawyers fight hard. They fight ethically. They're prepared. They do the best job they can to fight for the best result morally and legally possible for their client. That's all we can really promise to any client that comes. Welcome to Sebro and Slytherin, to the membership crew with a ton of new members. I love you all. I appreciate you all. I know this is difficult. I know this is hard. I know people have really seriously and strong opinions and feelings about this case. And I think that's what makes America great about this justice system, is that we care. We care about justice. We care about victims. We care about doing the right thing. And that's why we really have to make sure we focus in our energy on what is the question before us and trying to get the best question there, best answer to that question. So I appreciate you guys. This is a long video. Hopefully you enjoyed it. Sabertooth's going to gift 20 memberships on the way out. Make sure you guys all hit that like button. Tons of new members. Thanks to Sabertooth. You were amazing in this one. And there's a lot of people that should be thanking you here for all the memberships. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe.
You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.